Good morning. Perfect. So thank you so much for being here to this very interesting session where we will have three speakers, three EIC ecosystem partners. On my side, I represent the EIC Access Plus project. I'm one of the partners of this project coordinated by Antonella and the Innovas team. Gisela is our project officer, and I would like to first give her the floor to say a few words about the EIC programs and our role. Gisela, please. The floor is yours.
Yes, good morning, everyone. Thank you very much, Paul. It's a pleasure to participate in this new educational session that the team of Access Plus is putting in place to connect better our EIC partners and our EIC-backed companies. So thank you so much, Paul, and all the team of Access Plus for making this possible. And also today, so special thanks to our EIC partners who have dedicated their time to make it possible. So to Raluca, to Teresa, we'll have Elio a bit later. Thank you so much for giving an initial flavor to our EIC-backed companies, what your organizations are able to provide them as services to their specific needs. So we consider that those companies present here today. So thank you for trusting the EIC and the services that we put in place beyond the funding for you. Really can make a difference in your business development. So thanks a lot to you also, dear EIC beneficiaries. So Raluca, Teresa, thanks. As I was saying, you are giving a flavor of what you have in your organizations and that are able to help our beneficiaries. So thanks for this initial teaching, let's say, that today it's dedicated mostly to the IP, to the funding. So we are the EIC, we are very proud of this dynamics that we have created between partners and companies. And I really hope today will be a fruitful session for these specific topics in which you are specialized. So I will not take much of the time because time is precious here, and I'm really looking forward to hear Raluca and Teresa what they will have to tell our companies today. And I will be here throughout the session, so in case there are questions or the need of my intervention, I can come in a bit later on. So thank you, Paul, and the floor back to you.
Thank you so much, Gisela, and I also join you in thanking our speakers. The objective today is to give you a very detailed and comprehensive presentation of all IP-related topics by three of the expert EIC ecosystem partners. And we can start with our first speaker, Raluca from Oproyu Lawyers. Raluca, the floor is yours, please.
Thank you very much. Firstly, I would like to thank EIC organizers for the opportunity they gave me and for the wonderful job they are doing, not only by funding the companies, but as Gisela said, by making possible to join, to make meet the persons involved in the process of helping companies to innovate. I am patent attorney and European patent attorney for quite a lot of years. So my expertise is in the field of patent, which means advice, filing, and representation for European patents. That means patents filed at the European Patent Office, as well as international patents. That means applications filed with the International Bureau of the World Intellectual Property Organization. I will share the screen right away. Just 1 second. Okay. So I have a quite short presentation because I encourage you to contribute, ask questions or make comments whenever possible. So my presentation relates to the patent strategy for talented inventors, because I have the understanding that you are participating in this session in your capacity of inventors. And by definition, inventors are talented, because if they wouldn't be talented, they wouldn't be inventors. So I have structured the presentation in 5 small chapters: the timeline of the patent decisions, the fundamentals of patent protections, the decision when and where to file, some early warning signs of underprotection, and last but not least, some modest advices on how to engage efficiently with patent attorneys. So you have now the first possibility to interact in this session. You have created a new technical solution. It can be anything that is technical in any field of technology. So what do you do first? This is the question. So I encourage you to respond. Paul will help us with a poll. So right.
Yes, you will see in the chat the poll. Do you all have access to it?
Give the answer that you think, A, B, C, or D. Write what you do first. You write an article in a science magazine, you go out to find financing, you call your patent attorney, or you put the technical solution on your website. So only one answer, please. It's not all of the above, it's just one answer, please.
I don't see the poll, the question. Maybe it's only me, but
I don't see it either.
Okay,
we don't see
it
it
in the chat, or okay,
Yeah.
let's
No, you have.
try to launch it again. It came and disappeared. Okay.
Okay, we need to click on polls. Okay, I see. In the tab polls on the top. Okay. Yeah, that works.
Now it is launched again. I relaunched it. Can you see it?
Well, if you can see it, please write the letter corresponding to the option that you think it's best.
Yes, we can take maybe 1 minute for this. Perfect.
I know I can't.
Yes, we can for the moment answer the first question and then the second will come. You normally should click on the next button to see the second question, but for the moment, let's answer only the first one, please.
That means those that are that decide that A is the correct answer, no?
So in the poll, we have both your first question and the second that is at page 12. For the moment, we can answer only the first question, number one. You have created a new technical solution. What do you do first? Okay, so we have 12 answers for the moment. Uh, 13. So the majority of the answers are call your patent attorney and discuss when and where to file patents. And we also have 2 answers for the first and the second option. Write an article in a prestigious science magazine and go out to find financing for putting the technical solution on the market.
Okay, shall we wait for more or shall we go further? Paul, can you advise, please?
We can go further.
Okay. Now, which are the most frequent errors? of the inventors and applicants. The answer is obviously go and discuss with your patent attorney, but this will be discussed a little bit later. Now, most frequent errors of the inventors and applicants. The most frequent one is posting technical information before filing. That means, when I say posting, is making it public by any type of means. That means information shared with other parties without a non-disclosure agreement, or assuming that a grace period for disclosure exists everywhere in the world. There are some jurisdictions where it exists with some limits, but there are jurisdictions where it does not exist, such as the European Patent Office. So the most frequent and the most fatal error is if you make public any technical information in respect to your solution. So you shouldn't do that until you file for the first patent application, or until you decide that you want to protect it by other means, for example, a commercial secret, or simply the idea is not valuable and it's not protected, case in which you can publish it. So the first rule is don't publish anything until you take a decision on what has to be protected. That is the first and most fatal error. The 3 bullet points refer to this. Another frequent error of the inventors and applicants is that you file a patent application or several for the first invention, for the first stage.
Raluca, we can no longer see your screen. Can you please share it again?
Oh,
Apologies for interrupting.
I'm so sorry.
No problem. Probably it interfered with the service. So
yeah. Okay. I'm sorry. I'm so sorry. Okay. Now I suppose you can see it.
Yes, perfect.
Okay. So the first bullet points on the screen refer to the fact that you shouldn't disclose anything in respect to the technical solution before either you file the patent application or you don't file it but you don't file it knowing that for some reason it's better not to file it. The second very frequent error is that you continue with the research after having filed the first patent application. You have a better solution, but you omit filing applications for the later developments. And finally, another frequent error is filing too late because you want to make the solution proper and perfect. And the consequence is that competitors file first. So because of that, the purpose of what I'm telling you today is how to align your IP decisions with your roadmap. Roadmap generally refers on how to benefit from your technical solution. So the first important aspect which stems from the matters discussed before are to file before any non-confidential disclosure. And I think it's the moment to make clear that public information is all information that is not marked as confidential. Then you should link the innovation moments to the filing moments. So there should be some match between the filing of the application and the prototype, in case you have a product, and the product release. Obviously, you have to synchronize with funding. I'm not expert in funding. I'm sure that the experts in funding will tell you more, but from what I've learned from my inventors is that most of the inventors expect a clear IP plan and a clear ownership. Then, in connection with the need not to file to file before any non-confidential disclosure is to build an internal disclosure process specifically when it's a large company. You should have a very clear idea of who has access to the solution and who doesn't. And use the non-disclosure agreements as a safety instrument, but don't rely heavily on it. The best is avoid disclosure whenever possible. Sometimes it's possible, sometimes it is not. So now we come to the timeline of patent decisions, and the correct answer to the question is the first thing you must do is call your patent attorney. Now, the question you may have is why? And this leads us to the following chapter, which takes you basically through the fundamentals of patent protection. Some of you already know some of them, so I will go very quickly. Basic conditions for obtaining a patent in most countries of the world is that the technical solution must be inherently patentable, it must be novel, and it must be non-obvious. Now, novelty is destroyed if the technical solution is disclosed in an article or on a website or in a non-confidential communication. It's what we discussed before. So the first rule is don't disclose the technical solution until you file the first patent application. What does it mean that the technical solution must be inherently patentable? Well, it simply means that it has not to file to be categorized in the exceptions. There are some exceptions to the what can be patentable. For example, mathematical formulas and calculations are not patentable as such. However, if you do use mathematics, for example, for calculating the time to collision in order to improve the safety of a vehicle, then it is patentable because it serves a technical purpose. There are a lot of exceptions. I will not go through them. This is one of the first things that you should discuss with your patent attorney. If the technical solution by itself, that means without looking to what others did, is inherently patentable. Okay, so first rule, don't disclose before you file. Now, what's the purpose of patent protection? It's simple. It confers exclusive use to the proprietor, which includes the right to forbid third parties to use the patent. Patent protection is territorial. That means for the territory of each country. But the way to obtain a patent can involve regional offices. I wrote can because you can go only through the IP office of your country to obtain a national. For example, if you live in Spain and you want a Spanish patent, you go to the Spanish patent office. In this case, you will obtain a Spanish patent, which will not be valid in Austria or in France. If you file with the European Patent Office, this is a regional office having a centralized grant procedure, covers 38 countries as member states and some other countries with different extension arrangements, and after grant you have to pay for the territories where you want protection. This is in a nutshell what the European patent is. The International Bureau of WIPO is an international office governed by the Patent Cooperation Treaty. This has a centralized procedure for an international application. It's different from the European Patent Office, where you obtain a patent. With the International Bureau of WIPO, you don't obtain a patent. There is no international patent. There is international patent application, which must be nationalized in the countries of interest, which are at the time of discussing now, there are 158 countries. And national procedures involved in the national patent offices, such as UK Patent Office and so on. Well, what's a patent made of? Typically it has three parts. The ensemble is called in Europe patent specification. It has a claim section, which is a summary what is new. It has a description section, which expands the claim section with some details and mandatory examples of realization, and figures, which the figure section is optional, but most of the patents have figures because figures help to understand the technical solution. So the golden rule is that the protection conferred by the patent is given by the claims when interpreted together with the description of figures. This principle is certainly valid for the European Patent Office and approximately valid in most jurisdictions of the world. Now, second rule is take your time to learn the basics of the patent protection, at least in the jurisdictions you are interested. Well, now you may ask yourself, with so many patent offices and so many ways to proceed, how do I know which one fits me best to start and then to continue? Let's go to the next chapter and see. And now it's the second quiz for the and the second poll. If you want to go back to the poll and see
I have just activated the second one to separate the two questions because they were linked and we were only able to answer both at the same time last time. So now you should be able to answer only the second question.
Second question refers to the criteria for the decision. Which are my criteria and about when and where to file patent application? My budget, the markets where I want to sell, the markets where I want to manufacture, they may be different, the economic attractiveness of my technical solution, the time to obtain, and all of the above.
We already have two answers. 50% of them are all of the above. 23% is the markets. So the number of answers is increasing. Let's wait 30 more seconds.
Okay.
And we also have a question in the chat that I'm sharing with you, and you can decide, Raluca, when to answer it best. So could you explain the inventive step? Probably related to the previous slide, or
Yes.
if not, we can ask.
Yes, I will explain the inventive step just after seeing the result of the this poll.
Okay, so we have 20 answers. 53% of the respondents selected all of the above. Then on the second place, we have 23%, 6 respondents, the markets where I want to sell the technical solution. On the third place, the time to obtain a patent, 8% to respondents. And then on the last place, we have on an equal basis, one answer for my budget for the coming 3 to 4 years, the markets where I manufacture the products, and the economic attractiveness of my technical solution.
Okay. Now, my point of view is that all of the above are important. However, as the results of the poll indicated, they are not equally important, or the percentage of them is not the same for all. For example, for an inventor, the time to obtain a patent may be more important than for another inventor, while for some cases, the markets where they want to sell is more important than the budget or the time to obtain. So in principle, these are the most important criteria, but the percentage of importance varies for each potential new applicant. And now I will come back to the inventive step. And I think I will stop sharing because I want to explain the inventive step with the novelty. So let's think that the prior art has two characteristics. Okay. and you come with your invention. Well, I put the two characteristics with blue pencils. And the invention has two new or novel, as they are called, characteristics. So these novel characteristics must be invented. What does it mean? Now we bring into play a juridical fiction which is called the person skilled in the art, or the skilled reader. The skilled reader is less intelligent than the inventor, because the skilled reader does not invent. The skilled reader is skilled in the matter of the patent. For example, if the patent is for a medical device, the skilled reader will be skilled in medical devices. He will not be skilled in making shoes, for example. And the skilled reader has read everything that is published on Earth. Now, if we have these two characteristics of the patent application that are additional from the prior art, these have not to be obvious. That means that the person skilled in the art that wants to resolve a technical problem, knowing everything that has been published under the sun, for him, the matter should not be obvious. What is considered as obvious, for example, if I need to use a plug in a socket, now everybody knows that the plug and the socket function together. This is obvious, for example. It's a very dumb example. The essence of what is obvious and what is not obvious depends very much on the legislation of each country and, of course, on the practice of the examiner. Is it clear for the person who asked?
Abdul, is the answer that Raluca gave clear? Yes.
Okay.
The answer is yeah.
Then we should go further.
Yes.
And go further to okay, so correct answer all of the above. And the third rule, when and where to file patent application, the criteria for that must be discussed with your patent attorney, taking into consideration the people involved in manufacturing, selling, investors. Okay, now suppose now that we have already filed our first patent application. Do we have means for assessing if we are underprotected? What can we do? Now, the next chapter. In principle, you are underprotected if a significant part of your technical solution is not present in the specification, or you have not applied for protection in the countries that are of interest. For example, you manufacture the products in India and you don't have protection in India, for example. Now, mitigation depends a lot on the moment when you realize that you are underprotected. In some cases, it is possible to file new patent applications. When I say first rule was do not disclose. So if you have not disclosed the matter until the moment when you realize that you are underprotected, you can still file new patent applications. Fourth rule, make sure before filing the patent applications that you have all novel features in the specifications and that you have selected the countries of interest. And now we are coming slowly but surely to the end chapter, which is how can I cooperate with my patent attorney to achieve all the above. Now, Chapter 5 and last of this presentation is directed on how to engage efficiently with patent attorneys. Patent attorney should be your long-term advisor for all patent matters. We are living in a very complicated society. You need lawyers, you need insurance brokers, you need a lot of advisors for various matters. If you are an inventor, you should have a patent attorney as your long-term advisor. And how can you select your patent attorney? Well, one of the criteria is the technical field of the solution. If the solution is in chemistry, you should select a patent attorney that understands chemistry and can draft the patent attorney in that field. Then the qualifications of the patent attorneys, their international relations, if you want protection in many countries. Some patent attorneys are grouped into big firms. Some of them are in very small firms. Some of them have international relations, others don't. Then another piece of criteria is the time and the availability to respond to your questions. And the prices is last on the list. Why is it last on the list? Because you want quality. There could be another idea for how to select your patent attorney if you have the possibility to choose among various, because you are to select him for a long-term run. Try to see if there is any personal understanding with him. For example, if you are a very rapid person, moving rapidly, maybe you don't want to select a patent attorney that is a bit slow by nature, and vice versa. It functions better when you and the patent attorney have something in common when it comes to the style of work. And with this, I have come to the end of this presentation. I wanted to acknowledge the persons who helped me. And now I'm waiting for your questions or comments.
If you have any questions, please raise your hand and you can ask Raluca directly or put them in the chat as Abdul did. Maybe from my side, some of the major mistakes you've seen. No, so we have Abdul who has another question before me. Please, Abdul.
Good morning. Thank you very much. I mean, I'm in a position. My camera is not very much function, so apologies. So my question: one of our advisor suggests me to. Yeah, we have a patent which is on the PCT, which phase will be going to the national phase like in 6 months, and we have a preliminary report, and there is some clarification regarding the inventive steps. That's why I asked that question, so it's clear now. So the mentor suggests me to find an insurance company or a patent attorney where we can insure our patent, so that in case in a future scenario when we have some kind of infringement, we don't have to rely on like a 2 to 3 million court fee, especially fight with the bigger corporates. So my question is, what is your opinion, and where we can really find in Europe this kind of insurance where we can insure our patent? Is it a common practice? If not, is it advisable? What is your thoughts on this? Thanks.
Well, in insurance as such for patents, to the best of my knowledge, there is no insurance for patent as such. The way, for example, you have an insurance for some professions or an insurance for material assets such as a car or a house. If you have a specific country in mind and a specific threat in mind, then the best thing would be to discuss the matter with an attorney from that specific country, because but after the patent is granted, so you see, you talk about an international application. An international application has to be nationalized in the countries of interest. Once it is nationalized, it goes it will be examined by the national law, by the patent office of that country. For example, you want to nationalize it in Germany, then it will go according to the German law. So when the first answer is to make the difference between an application and a granted patent. As long as you have an application, there will always be a risk that you will not obtain a patent. And this risk cannot be insured to the best of my knowledge. So you cannot take an insurance to cover you in the case you don't obtain the patent. Now, once you obtain the patent, all the enforcement rules of the patent go according to the country in which you have the patent. So if your question relates to Germany, then ask a German patent attorney. If your problem is in France, talk to a French patent attorney. So this is what I can say at this moment with information I have at this moment. Other questions?
Yeah. Yes, thanks.
Thank you so much, Raluca. And Abdul, I also encourage you, Raluca shared her contact information, so you can also reach directly. If you could put it in the chat as well, Raluca, afterwards, but we will, of course, share your presentation with the contact information. Maybe shortly, in 1 or 2 minutes, I also had a question about the major mistakes you have seen in your throughout your career, and that could be shared maybe with the participants in protecting the IP from the very beginning properly.
Yes, the major error that the inventors that are researchers make is to publish an article. I know that publishing articles is very important for researchers. However, if you publish an article, it will be considered prior art because it's published. Once it's published, it will not be confidential. So what I recommend to the researchers is to hold the publication. So you write the article and you hold the publication until you file the application. Now the article can be published the very next day. So this is one of the things that I've seen which destroyed the novelty of some of the patent applications that I prosecuted. So that was one mistake. And another mistake, which is related to something that is very popular now, it's not in the presentation, is rely heavily on artificial intelligence assistance. Using AI for patent drafting is not a good idea. For 2 reasons, at least 2 reasons. First is that using AI engines does not protect you from your solution going through the internet. They are not protected unless you have a local AI which is isolated from the exterior. And on the other hand, the way that the AI assistants are programmed currently does not help you to draft properly a patent application. That would be the subject of another presentation, but long story short, don't use AI assistants for drafting patent applications.
Perfect. Thank you so much, Raluca. This is indeed also a very interesting question, in particular if the data comes out, the data uploaded by the users is available and can be used against them afterwards. But as you've mentioned, maybe we will organize a different session to go more in depth on this topic. For the moment, so thank you so much for the great presentation. I encourage everyone to reach out directly and get in contact if they have any questions. If you could share meanwhile your contact information in the chat, and in a few days we will also upload the recording and your presentations, the final versions, on the project website. Thank you so much once again. And I would like now to invite our second speaker, Teresa.
Hello, good morning.
Welcome, and thank you for your presentation. The floor is yours. Can you share your screen? Do you have the rights? I think, okay. If it works, perfect.
Yes. So if you can confirm that
yes, we can see
you can see. Okay. So first of all, sorry, something popped up here. Okay. First of all, thank you for the opportunity. It is a pleasure for me to share the opportunity with this such a really experienced professionals in the field. So just to introduce myself a little bit, I'm Teresa Sixto. I'm from FEUGA, that we are an institution that we are focused in tech transfer from different perspectives. So we work with a lot of different sectors, entrepreneurs, but universities as well. Researchers that are thinking about creating an entrepreneurship. So we work with a lot of different kind of sectors and needs. My background is biologist with an environmental engineer master thesis, but now we work the department that I'm part from in FEUGA, we work mainly in exploitation and commercialization of results in different fields, so from collaborative projects. So we have some examples of what we have been seeing in that, and entrepreneurs, and so we do all this part of defining the commercial plan for the results, including the IP strategy. That's why we are here today. So the idea is to explore with you how intellectual property can be transformed into a real strategic access for technology transfer and fundraising. So my presentation, we will be focusing in 4 key areas. So first, IP rights and technology transfer, technology evaluation and readiness, IP for fundraising, and commercialization pathways. So starting with IP rights and technology transfer, first of all, I think that with the previous presentation, we already have this perspective, but intellectual property includes a set of exclusive rights to the intellectual creations. And we can divide the intellectual property in 2 aspects: industrial property, that is where are included patents, and copyright. So each of these 2 major categories can protect different assets. So it's really important for us to understand this distinction and fundamental, because each project and situation requires different strategies, and we have to consider this. So related with this, we have this IP toolkit that is available as well from other, this toolkit is available by the European Commission. So here we have the most relevant IP rights that we can use in our strategy. So we can go through the most relevant for tech transfer. We already spoke about patents from Raluca in the previous presentation, and as we may imagine, it is the most powerful tool for attracting investment. But we have other kind of protections that are as well really relevant. For example, utility models, that is a more agile version than patents, and gives 10 years of protection. But we have as well trade secrets. They don't require a registration, but they are really difficult to value for external investors, because sometimes and usually the investors will require that we can verify that we are doing that correctly, and that takes quite a lot of investment. And we have as well trademarks that they have an unlimited duration, and we have to renew them every 10 years. The important thing is that each tool serves for different objectives, and patents, for example, create these barriers to entry, but trade secrets protects operational know-how. So we have to consider what we need and which is our stage in order to choose one of them. So why do we have this IP, for example, mostly in collaborative models that can be from different perspectives, and we will be speaking a lot about collaborative models. So IP defense, let's say, so it protects your product, secures your market share, creates barriers to entry, and allows you to avoid costly litigations. But as well, IP allows. So it allows you to be a strategic partner and collaborate, enhance your corporate value or the product value. It allows you to access to new markets and technology, and can generate new revenue streams. We will see examples about it. So IP isn't just a legal protection, it is as well a business tool. So as one example, we have to have why we should have an IP strategy is collaborative projects. So collaborative projects are initiatives in which several individuals or groups work together to achieve common goals. We can see here that there are different kinds of participants that can be part of these initiatives. So for this, IP takes on a different strategic value because multiple actors are participating, and it is important to have at project proposal stage this IP background defined. So in order to be able to participate in these initiatives with verified knowledge, and be able to claim what is coming from the initiatives with documented knowledge. So at a project stage, we will have this background, that is the pre-existing knowledge that we will make available for the project. Then this background could be transformed, let's say, in foreground. In this case, we will have the foreground will be any kind of tangible and intangible output of the project. So we will be able to claim the foreground we are involved if we have the background well defined and assigned to us. That's why it is important to have this IP defined before getting involved in collaborative projects. So IP management must be considered in this entire value chain, not only before, also during the implementation of the project and after the implementation of the project. How do we do that? So we should we should create appropriate agreements to share strategies for these results, ensure that intellectual assets are managed effectively, consider strategic value as protection, and build independence and long-term relationships. So with this first example of how valuable is the IP definition for collaborative projects, we can say that IP rights can be an exchange currency, can function as this, because it creates tradable assets for research outcomes, it enables a strategic exchange between partners, and is the foundation for technology transfer negotiations. It is difficult to negotiate without being able to claim the ownership of the thing that you are negotiating by. So which are the forms of IP exchange? So we can do a license, give the rights to use the IP in specific fields or markets. We can do an assignment, transfer completely the ownership, and we can give access rights, that it will be the example for collaborative projects. So you allow others to use your background, but within a scope. what is strategic in IP management when you have a lot of knowledge and you don't know how to manage the intellectual properties you are having in that. So always prioritize quality over quantity in the patent portfolio, because it is quite expensive and it takes a lot of time to fill a patent. And as we saw in the previous presentation, we have to have an expertise. We have to have a cross-functional collaboration between R&D, legal, and business, because to build the IP strategy, we have to have different perspectives. Early agreements to prevent conflicts are really relevant. Early agreements inside the teams that are producing the knowledge, but as well outside. And consider always the funder requirements. For example, the European Commission that we will see later is really intensive in what we have to do with our knowledge. And if we have something developed with that funding, we have to be aware of what is required by that. So our key takeaway: how we can use our IP. We can protect the IP. We can define our technology readiness level, perform the FTO analysis is as well something really relevant that we'll be speaking about that lately. Valorize, the technology valorization is possible because of having the IP. The commercialization strategy should be aligned with the IP strategy as well, and we can use this to engage investors for funding. So this asset can be really relevant as well at raising funding, that we are speaking about that today. So jumping now about technology evaluation and readiness. First of all, we have to consider the TRL. This is a TRL graduation that is available available as well. So we have from 1 to 3. If we are in that situation, we will have a concept and experimental proof. If we are from 4 to 6, we will have a lab validation and relevant environment validation. And we are from 7 to 9, we will have a prototype demonstration in a complex system in an operational environment. Usually, but this can change depending on the sector, the tech transfer will be executed at level 4-5 of development, but this can change. That usually investors want to see at least this level before seriously committing in the technology or in the product. So, as we already said, IP has a strategic value in competitive positioning, because it increases your market quotation and value. It gives you a more strong competitive position and improves your perspective, your situation versus competitors if they don't have it. It is it gives you higher profitability of intangible assets, facilitates the international expansion, guarantees exclusivity in exploitation, and is part of the corporate image. As well, the protection against fraud. As we said, this competitive positioning and the IP strategy value is fundamental. For having this, it is fundamental that you ensure your freedom to operate. So your freedom to operate is that you have the ability to perform a commercial activity with your IP knowledge, with your IP rights, without infringing third-party IP rights. So in order to be sure that you have this ability, you must know which are the third-party IP rights. For that, you have to do a patent search. It's essential. Which is the status of those IP rights of the third parties? Are they valid? And which are the geographical location of those rights? Because as we saw in the previous presentation, patents, for example, are geographical located. And this is fundamental for investors and fundraising as well. As well, in order to define our market potential, the market side is fundamental. We will not go through this a lot today because it will take quite another session to evaluate, but you have here the main aspects and aspects that have to be considered in order to define your market side. As well, to define your market potential. Your market potential can be evaluated from different approaches: the cost, the market, and the income. And each of the approaches has a different basis analysis. If it's basis analysis, and as well, each of the approaches usually is best for different kinds of developments. So this is as well a bit tricky and complex. So it is for you just to know that you have to consider a lot of different perspectives in order to have this market and commercialization strategy defined. So jumping in IP for fundraising. IP rights are a defensive tool, as we said, because it secures your market share, it enhances your competitive, and it gives barriers to entry. But, and as we already said before, European Commission is as well really focused in improving the IP strategy that they are developed results under funding from the European Commission have. So there are some requirements that those that are involved in funded activities by the European Commission, they have to commit. So, for example, the European Commission gives us the obligation to protect the results that are produced under funded activities. But as well, IP can also be a liquid asset. So we have here a couple of examples that are really visual on how valuable can be the IP. So we have this example from BlackBerry. In May 2023, BlackBerry completed the sale of sustainability, all of its non-core patents to another company. I have here the numbers. So in the closing, they acquired the closing with 170 million for 32,000 of non-core patents and applications they have. Even selling all of these patents, BlackBerry retained the patents that they were needed for their core applications. And they kept certain existing revenue generated agreements. So this is a clear example of IP acting as a monetizable asset, even when the product momentum changed, because we know that BlackBerry products lost a lot of market to other marks. A well-structured patent portfolio allowed BlackBerry to give an alternative path to value. So they were able to acquire cash for that assessed they had. In this case, the IP value depends on the strategic of this case highlights that IP value depends on the strategic objective. So here, the objective was to unlock cash and flexibility without disrupting the customer or the core business continuity. So for the investors, this means that IP is a liquid asset even when the product fails. It acts as an insurance policy, and it offers exit options beyond the traditional market and acquisition activities. So even that BlackBerry already didn't have that operational business value, they had this portfolio that gave strategic power for the company. And then we have another example that is from Moderna, that I think that maybe we all know about this company, but this company started way before, not that much before COVID. So in December 2018, Moderna completed the largest biotech exit agreement in history at that time. And they raised a total of, I think they were allowed $600 million, achieving a valuation of 7.5 billion at that point. The company at that point had 0 approved products in the market. Every single candidate in their pipeline was still in early stage trials, phase 1 or phase 2. Typically, biotech companies without products are valued between 500 millions and 2 billions of dollars. But Moderna at that point was 7.5 billions dollars. That was from 4 to 7 times more than higher than the habitual things. And why was this the situation? They had more than 170 issued or allowed U.S. patents, more than 110 international patents, and more than 430 pending applications worldwide. That was quite a lot, and I mean, it is a really special situation and a really powerful company. It doesn't mean that we have to have all of these in order to be valuable, but it's quite an example that having this huge IP portfolio with a lot of strength allowed this huge investment without even having any final product in the market. But more of this, over this, the patent protected a platform, a technology platform that were just not allowing them to develop one drug, because they had this scalable platform that could generate products across multi-therapeutic areas. So it was not just they had it protected really strongly, but they had an scalable platform. So it's quite a really special situation. So the key takeaway from this example is that a strong IP transform early stage science into a huge investment before even having a single product reaching the market. Having this platform allowed the company to produce the first COVID vaccine in just 2 days. And so that's quite a really impressive situation. And the investors really saw the potential of this company before even reaching market. So we have to be really, really glad for this agreement. So what we have to have in our checklist when we want to build this investor due diligence, we have always tried to have the ownership of the IP defined. If it's ours or if it's from a collaborator or a competitor, we have to have that track. We have to have the freedom to operate and the knowledge of that. We have to have the patent landscape executed, an overview of competitors and market landscape, and we have to have which are our existing licensing agreements, to have all of that track, so we can share this with the investors in the most agile manner possible. So just as a summary, IP is a strategic assess that can multiply the valuation of the product and the company, and the investors see this as a revenue, because it sees a market competitiveness tool, revenue streams tool, and technology demand potential. So going into our last section, it is about commercialization pathways. So we have, as a summary, these are the three main options because depending on the sector we could find another kind of options, but the three main are this: licensing, creating a spin-off, and co-development. These three options can be categorized and can be choose depending on the perspective that we are analyzing. If we are analyzing the product from a user perspective, sorry, we can have the potential of use it by the owner, but we can also let be used by somebody else. For that, we can sell the IP, license the IP, create a spin-off, and co-development, engage in a co-development with other partners. As we can see, each of the strategies have a different situation, different risks, and are suitable for different kinds of assets. If we see it from the owner of the IP, who is the who owns the IP, we can say that the original IP owner keeps the ownership. For that, the pathways will be license and spin-off and co-development. And we can see that the ownership is transferred to a third party. In that situation, the pathways will be a co-development as well and selling the assessed. In both situations, we will need to have agreements as soon as possible. So which are the success factors and next steps that we have to consider in order to commercialize our IP? So IP protection. Your invention should be properly protected, and you have to be sure who owns the corresponding IP rights. Again, freedom to operate. We have been facing when we give assessment to, when we help the owners of the IP, everything is going really fine. And finally, when we ask them if they have done this analysis, they tell us no, and we find barriers in that situation. So we really insist in that because it's something that we have seen as an issue. And investors engagement strategy. You can have a huge IP plan and with a lot of patents and so on, but if you are not able to show the investors your value proposition, your materials, how you can help the society, which is your patent portfolio, if you are not able to communicate your value, then you will not be able to raise this investment, because you will not be able to catch the attention of investors. So this is why as well a really huge and really relevant part for commercialization. So we will let you hear as well a really useful material, because we always try to build this kind of activities in already available materials that are already for user friendly. So you will have here more material to go depth in what I just spoke about. And after that, just to remember you that we are part of the EIC service catalog. That's why we are here as well today, because we are involved in this community that is really relevant for helping you. So you can check which are our services, and if you want to know more about our general services, you have here my contact. And I know that maybe it was quite a lot of information, so if you have any question about this, you can ask me, and I will try to answer you as best as possible.
Thank you so much, Teresa. Maybe as a reminder, since you said that EIC Access Plus will cover 50% of the costs of the access to the services of the EIC ecosystem partners. So the applications are very easy and open on our website, and the team is fully available to answer all your questions and support. There were several questions asked during the presentation. I didn't want to interrupt you. Shall you ask your questions directly, or do you want me to ask them on your behalf? Janos, you were the first one.
As you want, yeah.
So the first question from Janos was, if know-how is written and formal, isn't it an IP instead of copyright, since it might contain technology innovation as well?
Yeah, well, that's why we always include that slide, because IP is everything. So it doesn't mean that copyright is not intellectual property. So in English, we have intellectual property and industrial property. So everything will be IP. However, we have these two major, well, maybe Raluca, you are better to explain this, because maybe you have more technical perspective for that, but everything is IP. So we have intellectual property, that is the total, and we have industrial property and copyright. So it will be it will be in the section of copyright, because it's not an industrial property as it says. So it's not a technical innovation, a design, it's not a patent, and so on. So it's this other way of protecting the knowledge. So it is just a matter of names of how do you refer to what you are protecting, let's say, how you are protecting it. I don't know if it's okay, if I explain myself correctly.
Can I add something?
Yeah, totally.
Industrial property usually is protected via a title, which is more tangible and easier to enforce. When it comes to copyright, it's a bit liquid, so not very, does not have consistency. So if there is a piece of advice to be given, is do not rely exclusively on copyright. Copyright should accompany, whenever possible, the industrial property titles, which means patents or utility models or design patents or the like.
Thank you so much, Raluca and Teresa. I'm also sharing Janos's congratulations for the great presentation, and he said the answer was clear. Elio, you also want to add something with respect to this? Welcome, Elio, our next speaker.
Hello, thank you very much. Yes, I would like to complement what it was said by previous speaker and the other participant. Yes, indeed, there are title rights like patents, trademarks, designs, and title rights. So in untitled rights like copyrights, let's say the filing and registration is a way to reverse the burden of proof. And so, I mean, it's not easy to enforce these rights. So, for instance, if you like to protect your software, the plan A is always to try to protect it through patents that are, let's say, a certified procedure where a public authority carried out a substantive examination and then at the end issue a registration certificate. So in terms of, let's say, fumus boni juris, that is what you need in order to start a legal action. It is much more safe. And also when investors are carrying out a due diligence, the weight of patents, trademarks, and design is much higher than the weight of the other untitled rights like copyrights, know-how, or trade secrets.
Yeah,
Thank
totally.
you so much,
We call these strong and weak rights, let's say. So patents and so on will be that strong ways to protect your knowledge, and copyright and so on will be the weak ways to protect it. But well, it depends on the assets, and we have to consider all of them.
We have a few more questions for you. Teresa Abdul asked if one should do regularly FTO search.
Yeah, okay. So this depends as well on your capability of doing that. FTO takes quite a lot of time, let's say. So if you are doing it internally, if you have a budget allocated, a team allocated, then it makes sense, because it is a sector that develops really fast and creates really fast new knowledge, because there are sectors that are more stable than others. If this is a sector that is quite active, then you should do that more regularly, because that will be helping you as well to identify competitors and other things that you can get, strategic knowledge that you can get from FTO. But there are other sectors, or if you don't have the resources to do that, you have to be more strategic on when to execute these activities. It will be really nice that we can do everything all the days and check everything really regularly, but you have to be aligned with what you can do and with the sector you are working on. At least the FTO should be at least preliminarily executed, by my perspective, before patenting, for example, or before defining your IP strategy. It should be at least a preliminary analysis before, when you are defining your IP strategy, because you could change your decisions considering what you have found.
Thank you, Teresa. The next question, maybe very quickly, because also Elio will probably go more in depth on it, is how is the portfolio value evaluated and who evaluates it?
On who evaluated, it depends on who are you addressing. If you are addressing an investor, then the investor will evaluate it. If you are addressing public funding, then the team of the public funding body will evaluate it. So it will depend on who are you reaching at that point, and how. Well, it's quite a lot of things to speak about this. So it will be taking which kind of protection you are incurring. So you have a sector you are. How was your, for example, you have a patent. What was the analysis that the patent body did, and if it was a strong, and if you got really good analysis or less with a lot of requests. So it will take quite a lot of different perspectives.
Thank you. So we have the last question is so two questions related to the same, let's say, challenge. One from Ricardo, mentioning that if every patent costs around 25 kilo euros times a large number of patents, that would not be a good business for such an amount of value for telecommunication patents. Is this the case? And then the second from Anna, who is mentioning the same thing: high cost of patenting in numerous countries, in particular for patent portfolios. It's a big challenge for startups that are not backed by the universities. And then attracting venture funding becomes necessary. And the question is, what is reasonable share? What is the reasonable share that can be proposed by a startup to venture investors in exchange for funding? I think Elio will go more in depth on this topic as well. So will submitting a national application with own funds to set a priority help strengthen the position of a startup in front of venture investors? Maybe very quickly, because I think that Elio will also go in depth on these topics.
Yeah, I think that about the question about Ricardo, I think is related with the example of Lockberry. And in that situation, the issue was that they were in a really tough situation. So it was the best they could get at that point. So it's quite a special situation. We are not maybe valuing if it was really such a good deal. And about Anna, what in general I can say is that you should try to make use of the public options and support you have available for entrepreneurs, because you are in quite a tough situation. And if you can have this registered, the priority registration as soon as possible would be the best. But well, that will take quite a lot of more discussion to go through as well.
Yes, thank you so much, Teresa. And I think that in addition and in complement to EIC Access Plus, there are also national schemes to help funding patenting for small companies. So I'm not familiar with the schemes in each country, but in France, for example, there are dedicated measures from the government to support early stage companies to protect their IP. And even maybe very simple measures like the envelope solo that costs a few tens of euros and sets the precedence in a domain. Yep. Thank you so much, Teresa. One last request from the participant is to share your contact information. So if you could do that in the chat, and I will also subsequently share your presentation with everyone.
Okay.
Thank you so much once again. Elio, I don't know if you can still hear us.
Yes.
Sorry for the slightly late, please.
No problem.
The floor is fully yours.
Well, I was exactly, let's say, participating to I'm the expert of the Italian government for this IP-based finance working group at UIPO. So I was participating to that table. That is a very interesting project where we are carrying out and trying to support the use of IP in order to finance, in particular, startups, SMEs, and spin-offs. Now I would like to share my screen, but I see that I'm not allowed. So probably
give me 1 second. One second, of course. Apologies for this. Now you should be able to share it.
Okay, great. So can you see my screen?
Yes.
Okay, great. So I was requested to merge 3 topics, and each of them probably would request, let's say, some hours for being dealt with. But I will do my best to be brief, also considering that some of the topics have been already presented. So my name is Elio De Tullio. I'm the founder and managing partner of De Tullio & Partners. That is an IP tech law firm. So this means that we provide all IP services from searches, patent filing, prosecution, litigation, surveillance system enforcement, customs enforcement, or civil, criminal, and administrative enforcement. I have some tasks. I'm one of the experts of UIPO, member of the board of the ISME, the International Network of Small and Medium-Sized Enterprises, and I have other tasks always related to intellectual property. I'm also one of the experts of the European Commission in the China and Southeast Asia and Africa IPR SME help desk. It's very easy when you like to promote your business, when you like to attract investors, and then at once you realize that you are not in the condition to attract investors. This problem was when a startup discovered during the due diligence that the freelance developer retained a copyright ownership over critical software modules, and there was a problem because then this caused the pause of negotiation for 4 months, and the company was nearly to collapse. Another case happened just a few days ago. A very interesting startup involved in neurosciences was involved in very long negotiation with an investor, and then at the end of the day, after this negotiation, the contract finally was submitted to our attention, and we realized that one of the conditions, the pillar condition for this negotiation, was the assignment of all intellectual property rights. That was not really a way to control the negotiation and to establish a balanced roles in the negotiation itself. So after some weeks, we managed to let's say, convince the investor that that was not a good way to proceed, and to change, let's say, slightly amend the provisions, opting for a license rather than an assignment, so making this more sustainable for the startup. So there are a lot of cases that can happen on the ground when you are involved in these IP issues, and you always realize how important is IP at the end, when probably you are getting, let's say, the results of your efforts. So just a quick introduction. Probably most of the information have been already presented. From this slide, I will take, let's say, the message already mentioned before, that if you have a software, if you have an app, if you have a protocol, it's always better to, first of all, to perform a state-of-the-art search. This will allow you to understand if you are in the main condition, the basic condition for protecting the software or the application as a patent. So provided that it has a technical feature, let's say, and it generates a further technical effect. But this is always the plan A, because the other solutions, the copyright over the algorithms of the copyright over the source code, or even the trade secrets approach, they are, I would say, probably apparently less expensive, but at the end of the day, they are weaker as a kind of protection. So I also answering the question that was posed before in the during the session, I would say that using priority rights and starting with national filing, you can keep, let's say, the exclusivity for almost 3 years, 2 years and a half, using also the PCT path for probably 10,000, 12,000 euros. That is including taxes. So this is not really a high value, and 3 years is a reasonable time in order to start negotiations and trying to attract investors. Usually opportunities are not lost because technologies lack value, but because there are some problems in the due diligence. There are some ownership gaps. There are weak patent positioning. Let's say patents are not, let's say, are not enough solid. They do not have inventive step, and the risk mitigation approach is very low. And this is something that investors look at during, let's say, preliminary phases. So this journey should start from the very beginning with some preliminary steps that are, let's say, a way to foresee possible future problems. So early legal planning transforms IP from a technical outcome into transferable, investable, and financeable business asset. So this is, let's say, an ideal innovation journey, starting from searches in order to check if you are reinventing the wheel, or you are just, let's say, investing money on something very innovative, very attracting for investors. You can start, once again, with protection. I would say an holistic approach to protection. So protecting title rights, patents, trademarks, designs, and then, of course, also consider untitled rights. Start with national filing is a good cost-effective approach. And then, of course, the FTO allows you to understand if and to what extent you can have problem in using the results of your researches, and to see if there are any problems in terms of your research results. IP evaluation is one very important topic. It's not easy to use IP as a collateral, but I would say that the perimeter and the strength of the value of your IP, the economical value of your IP, is defined by the quality of your IP portfolio. There are a lot of methods. We will speak about methods afterwards, but what I would suggest is not to wait for somebody else that value your IP asset. You should have your IP valuation report in your hands, performed by your experts. Usually the IP valuation is carried out by a team of experts with economic background, legal background, IP background, also market background. And then if you have this, if you have these reports in your hands, then the investors can rely on them, and they should, let's say, perform another valuation. We have performed an evaluation for in the framework of European project for probably more than 100 consortium or universities, research centers, according to this IP Booster project. And I mean, this was a great help for these team groups in order to, let's say, attract investors and also promote their own research results. We will speak briefly also about licensing and, of course, investments. How can you prepare for technology transfer? So technology transfer is the controlled movement of knowledge, inventions, and capabilities from creators to users capable of commercializing them. You can have a lot of models. We have also seen some of these models before. Of course, the categorization of these the relations between universities, startups, spin-offs, and investors and businesses can vary. I would say that can vary also from country to country, European Union, because in European Union, consider that research results are not let's say, ruled and regulated by countries in the same way. For instance, in Sweden, we still have the professor's privilege. In Italy, the professor's privilege was abolished just a few years ago. And now we have also new guidelines for the assessment of the relations between businesses, startups, and investors in IP and research results performed according to financed research financed and realized by universities. So successful technology transfer depends on legal clarity. Contracts are, let's say, one of the pillars. When you approach technology transfer, probably the first thing is confidentiality. Confidentiality can be secured by NDA or, let's say, upgraded versions of NDA like NNN, non-disclosure, non-use, non-circumvention, that in some jurisdiction allow you to enter into agreements with third parties in a safe way, also being secured that they will not circumvent the agreement, like in China. Inventorship must be accurately documented because otherwise, if the applicant has not in his hands the assignment by inventors, then can have problems also in prosecution phase. For instance, USPTO requires mandatory assignment in case of prosecution of even, let's say, US portion of PCTs. Employment contracts must assign rights correctly. There is enough freedom to regulate the ownership of IP rights, but of course, in case of employments, there are some rules, in particular in some jurisdiction, to observe. For instance, fair compensation or a right of first refusal. So, I mean, everything should be considered according to the jurisdiction of the contract or the applicable law or the jurisdiction of the parties involved in the agreement. Patent strategies must align with commercialization goals rather than academic publication timelines. Of course, publications can destroy novelty, and this is can be a very big challenge for, in particular, patent filing, because can be void. Not every innovation should become a patent, but be aware that trade secrets protection is not for free. In order to have a trade secret, you need to have implemented in your organization technical, legal, physical measures in order to preserve the secrecy. And moreover, you should have assessed the, I would say, the secrecy of this information, so they shouldn't be publicly available. And then, of course, you need to have also assessed the economic value of this information. Otherwise, no trade secret protection can be requested, and the counterparty involved in a dispute can object to these arguments. Technology transfer structures and architectures may vary depending on commercial goals. So you can have, as already mentioned, licensing model, where the exclusivity or non-exclusivity licensing is a matter, as well as the territorial aspects, assignment of IP rights, joint development agreements, research collaboration contracts, co-ownership. These are all models whose details are assessed on the basis of the agreements themselves. According to my knowledge, our observatory, I would say that in particular in European projects, the main concern is to, of course, to get the money. And so I would say agreements on the foregrounds and of course on the background specific agreements are not really, let's say, a priority. And these problems come up probably when the end of the project is approaching, and when probably sometimes it's too late in order to balance the strength between the parties. So legal structuring determines revenue streams, liability allocation, and future innovation control. The identification of what you have in your hands and what you can use is also a key point. Sometimes you don't even know what you have in your hands. Sometimes the innovation, what can be protectable through IP, is in intermediate processes or hidden results, or sometimes in production phases that are achieved through innovative tools or methods. Sometimes this, let's say, preliminary assessment is very important, because if these are not, let's say, mentioned, for instance, in a negotiation, they cannot have an economic value. Sometimes startups, spin-offs, or companies take them as granted because they are not able to recognize them. So disclose, and of course disclose, first of all, to themselves, these potential IPRs is crucial. So the identification of transferable assets is a key point. And of course, this in order to establish a correct, let's say, level of strength with the other party, in some cases the investor. Even the evaluation and valuation of brands is very important. You are recognized and recognizable on the market through your brand, and even in case of brand, you have several methods in order to evaluate your brand. Some of them refer to ISO standards or IDS standards, but in any case, even for trademarks, it is better to have in your hands the valuation, the economic valuation of your asset before starting any negotiation, and before, let's say, before that the counterparty or the other party or the partner start to its own evaluation. You can use, in order to start your IP protection path, you can also use, of course, the EIC program, but also some supports like the SME fund support, the ones launched by UIPO some years ago and still ongoing. Be aware that they will be available for sure until April, May, probably some of them also until October. So you can use these funds in order to start the process with a trademark filing or a patent filing or a design filing. You can also use IP scan that is available in some countries, and IP scan, this IP pre-diagnostic service, is available in order to understand which intangible asset should be protected, what type of protection is appropriate, and how IP can support long-term growth and competitiveness. FTO is always a good option, as we have listened before. The FTO allows to, let's say, predict what can happen to what you have protected or what you like to just to use in case you like to, let's say, extend your commercialization in particular at international level. So it reduces litigation exposure and strengthens negotiation credibility, because if you have a very good report, further an FTO performed, then you can liaise with your potential partners or investors in a better way. On IP valuation, I mean, this is a very important topic. I'm very passionate about this topic, but it's very complicated. Once again, professional valuation combines legal expertise, market and commercial expertise. Sometimes they are involved also CPAs, accountants, and also public notaries in order to certify the validity or your evaluation. They can allow owners to understand the market impact and revenue potential, the technological relevance and legal strength, and the competitive advantage and scalability. You have different methods that can be used. Usually there are subjective and objective factors that can influence valuation and evaluation. In any case, valuation is a very good way to support venture capital negotiations, licensing, royalty determination, mergers and acquisitions, also tax structuring and transfer pricing transactions, and IP-based financing strategies. A lot of factors have an influence, an impact on IP valuation. Once again, what you have done before filing is very important. If and to what extent you have protected title rights, and of course, what are the untitled rights that can complement this protection. The strength of claims and of course the search reports received, even the registration already granted, have a role. So the quality of what you have done have an impact on numbers. The geographic coverage is also very important. If and to what extent the regulatory framework allows you to go in some countries. Think about China, where not all technologies can be part of, let's say, export. Litigation exposure, because the litigation risk is a part of the value, can reduce the value, and licensing restriction. Once you have all this information, and then you can involve experts in order to perform evaluation. The evaluation models are these mentioned in this slide, qualitative and quantitative. I will not go through all them, but I would say that they are chosen according to the recipient goals, but also according to the type of transaction or negotiation in which the recipient would like to enter into. The most commonly cited reason for conducting brand valuation are, of course, strategic planning and negotiation with investors, but you can also perform evaluation for obtaining a loan, for taxation planning and compliance, or for litigation support in order to understand what is the amount of damages that you can request in case of dispute. Fundraising using intellectual property. Of course, we have spoken about fundraising in all the presentation. There are some also very interesting reports and researches that can be consulted, like this performed by EPO and the UIPO, that shows a strong correlation between patent and trademark filings and the company's ability to secure investment. But during the due diligence, investors ask some very critical questions that are part of your preparation to answer correctly. So can competitors easily replicate this innovation? Do the founders truly own what they intend to commercialize? Are there hidden legal, regulatory, or litigation risks? So when you are selling something, you fully know what you are selling, but sometimes the buyer doesn't know all details of what you have in your hands. Of course, there are some tricks in contracts like declaration of warranties and others, but in general terms, I would say that the company, the startup, the spin-off should be ready to answer these questions. Another typical question can include who owns the IP, if the inventors properly assigned the invention, does the company infringe third parties' rights, are collaboration contractually secured, and can protection support international expansion, sometimes leaving some countries or not extending, for instance, patent protection through the PCT or through other systems can be, let's say, a way to weaken your position. For instance, I know a lot of cases recently that further to the introduction of the unitary patent, let's say, made some companies or startups forgetting the possibility to validate European patents in those countries that were not, let's say, part of the unitary patent, so the European patent with unitary effect, because there are different deadlines, and sometimes these deadlines are not clear in the minds of right holders. So across the 5 IP issues that frequently stop investment rounds, across technology sector, recurring legal problems repeatedly delay or terminate transactions. For instance, missing inventor assignment or founder ownership disputes, or the also the level of aggressivity of some competitors, or the level of let's say reaction of some competitors can be under-evaluated. Premature disclosure destroying patentability, open source software compliance risks, weak territorial licensing clauses, lack of freedom to operate analysis. These risks identification can protect in case of valuation and negotiation. Of course, IP-based finance is also a very interesting option. Is not, let's say, so easy, because banks are reluctant to provide money and to give money based on the securitization of IP rights. But things are changing, and let's say there are a lot of tables at European Union level in order to strengthen the possibility for IP owners to get loans using IP as collateral, and these are, let's say, these are still based on IP valuation. Licensing is also a fundraising strategy. Sometimes licensing is a way to find the right matching with other partners, and to, let's say, to internationalize your initiative, not moving from your home. Equity investment is also a good point. Evidence shows that strong IP protection directly attracts capital. A first patent filed and registered can increase venture capital funding by 76% within 3 years, and IPO funding by 128%. And investors look for sustainable competitive advantage, defensible market positioning, and clear commercialization opportunities. So you equity investors usually would like to invest on initiatives that can maintain their market and competitive position in the world. Strategic partnership is also a way. In some countries, you need to check if you can partner with other entities. It's a good value for IP owning company, a good value for strategic partners. It is a matchmaking that combine respective strength and weaknesses, and the result is that well-structured IP partnership can create shared value, stronger market position, and scalable growth opportunities for both sides. What are the obstacles in IP when fundraising? Usually, some consideration. IP as a value driver, so IP rights can increase investor confidence, in particular if they are genuine. The investor can rely on you, in particular it performs the due diligence, everything is okay. Usually IP protection requires financial investment that sometimes are perceived as cost, but when you start a negotiation, then you realize that they are not cost, they are a way to have let's say and to receive a higher value for your company. Also, this cost should be balanced. Of course, sometimes there is I would say a fear that these costs are so high, but there are some tricks that can be used. Priority is one of them, and the other one is to combine title and untitled rights. Another very good tip is to always activate surveillance system on what you are doing, on registers, on market, e-marketplaces, e-commerce platform, in order to see if and to what extent somebody else is doing something similar to yours, because being alerted is and so knowledge is a way to consider other plans and other solutions. In assessing the value of IP protection, it's very important to unlock revenue opportunities. Once again, builds investor confidence and mitigates competitive risk. Competitive risk is, let's say, the risk that your solution is copied or imitated. Of course, in this case, you need to allocate some money to react, but you can also find some insurance schemes that are available in your jurisdiction or for your type of company. I will skip this part because we are running out of time, and I will go straight to the end. There was a part of on licensing. These are some practical tips that you can use in order to notify to the public that you own some IP rights. Very basic. By the end of the day, if the other parties do not know that you have some IP rights, probably they will underestimate your capacity to, of course, to be innovative and to enter into very strong negotiations. And some conclusions. So these are, let's say, the points that a company should consider: IP valuation, IP-backed loans, licensing and commercialization, equity investment, strategic partnership, and the sooner the better is the final message. So the sooner you start your protection, the better it is for your approach and the capacity of fundraising your initiative. And are you ready for technology transfer or investment? You need to be ready to answer these questions. There are some common mistakes innovators make, like premature disclosure destroys patentability, informal collaboration creates ownership disputes, generic contracts overlook strategic goals. There are some cases in which there are no contracts. People think that shaking hands is enough. That's not true. And filing without commercialization planning wastes resources. So a possible right order is identify protectable assets, perform IP searches, structure ownership chains, register title IP rights, assess untitled IP rights, prepare technology for transfer, support valuation exercises, conduct IP due diligence, negotiate agreements aligned with long-term commercial objectives. That's all. Thank you very much.
Thank you so much, Elio, for the detailed and comprehensive presentation. There is the first question from Wolfgang. How can one get access to the mentioned SME fund support?
Well, it's very easy because you can go to the UIPO website. There is a special page that is the UIPO SME Fund 2026. You will find, let's say, a form to fill in, and you need to include all the information about your company, and then you file the application. You receive a voucher, and the very important thing is that you don't have to start the activities before the voucher has been received.
Thank you so much, and thanks, Antonella. You have already copied the link in the chat. Another question from Anna. I don't know if you want to ask directly, Anna, or if I should ask on your behalf.
I can actually ask. Thank you very much, Elio, for comprehensive presentation, very practical insights, and I feel that you have the very practical background and you know much more than you have explained. Could you please share your email address, because I have also some strategic issue to you on the practical background. Thank you.
Yes, of course. You can, let's say, you can find it in the chat. Thank you.
Okay, above. Thank you. Thank you.
Perfect.
Any other question?
Well, actually, could I ask a question regarding this, your last slide? How was it? The new words for myself. It's structuring the ownership.
Yeah. Well,
so how is it done usually?
Well,
when
usually
numerous stakeholders.
Yeah, I mean, ownership is a big issue, because usually either in case we are talking about simple, let's say, co-owned, let's say, patents, but sometimes even if we are talking about research projects that are co-developed, let's say the assessment and the regulation of this co-ownership is not made. I mean, people think that they can rely on, let's say, verbal agreements or even the percentage of patent ownership in the application is enough. Usually, you need to regulate the relationship with the other partners, even if they co-own, for instance, a patent application in a separate document, that is the co-ownership agreement, in which you define terms and conditions of this co-ownership, because in particular, in the worst case scenarios. These are not so complex agreements, but you need to invest some money in order to, this is a risk mitigation. I mean, we are all good persons when things go well, but sometimes things go wrong, and we need to be prepared that our business is safe and we have mitigated correctly the risk to fail.
Perfect. Thank you so much. Are there any other questions for Elio or for the other speakers as well? In any case, you already have their email address, and we encourage you to contact the speakers to discuss more in depth with each of them, maybe some topics that might be confidential. And as mentioned, in the next couple of days, we will prepare and share the recording and the individual presentation. So I would like to thank once again all of you for participating, and also ask Raluca, Teresa, and Elio to share the final versions of their presentations, if there are any changes with respect to the ones that I already have. And for the closing words, I don't know if Gisela is still connected. Gisela, please.
Yes, thank you, Paul. I think it was a very interesting educational session. You went really into deep details, Raluca, Teresa, Elio. So thank you so much for that. I hope our companies present here today really profited from your experience, knowledge, and know-how. From the questions and answer session, I really saw a very integrated knowledge in the sense of their needs. So thank you very much. I hope to continue counting on your services for the future of the EIC-backed companies. We have new cohorts coming in the accelerator transition. So every year we have a whole new portfolio of EIC companies. So we count on you also to help the future EIC community. So from my side, thank you so much. Hope to meet you all in future events of the EIC. So soon to come, the EIC Summit in June, 3 and 4 of June. So hope to see there our partners and also you, the companies there. So soon you will have all the information, and we can all also come together in this big EIC summit and develop all these knowledge so much important for the business development of our innovations in Europe. So thank you very much from my side. That's all, and see you all very soon. Back to you, Paul.
Thank you so much, Gisela. And on behalf of the EIC Access Plus team, Antonella is our coordinator. I would also like to thank everyone and see you soon, hopefully at the EIC Summit.